so we talked about who currently holds office. Is anyone running for office, and what scale of government? I don't need to know, like, in this county or anything, but what scale of government are we talking about in what position?
Town board supervisor. Town board supervisor.
Town board is synonymous with township?
Township.
Okay. Sorry, I just wanted to check. Local government structures are different in every state. So, like in Washington State where I live, we don't have townships. So that's an interesting level. I'm like, well, what are the powers of the township, and how is that different from the county, and how is that different from the city? And so how we divide that up varies dramatically based on each state, which is a good lead-in for me saying that what I'm giving here is not legal advice. I'm not a licensed attorney in the 3 states from which people are from. I can give legal information like anyone can, but if we start to get into the facts of a particular thing and then how the law applies to those facts, that is usually where, you know, what you should do based on those facts becomes legal advice. So don't worry about like feeling like if you're asking too detailed questions, I'll filter that. Feel free to like get into whatever you want. I'm just saying that that's a limitation on me, that I'm not able to give legal advice in the 3 states that we're talking about. That's part of the reason why we've mentioned to a few folks in some of the community groups about the need to find attorneys who are licensed to practice in the particular states we're dealing with. And my advice on that is that it's not attorneys who are familiar with local government law or constitutional law or community rights law, if there is such a discipline, or water law or CAFO law or environmental law or land use and zoning or state constitutional law. The particular subject matter is irrelevant. What is important is that the attorney that you're finding understands that civil disobedience is a legitimate strategy for changing unjust laws. And 2, understands the community rights approach to legislative civil disobedience. In that respect, I would recommend looking for attorneys who are associated with the National Lawyers Guild, which is a national bar association of radical and progressive attorneys. And we only need 1 attorney per state. It doesn't have to be a local, it just needs to be somebody. And I mean, given that there's the Twin Cities and Madison,
There's one in Milwaukee. I looked it up.
Yeah, so I mean, we've got a lot of radical attorneys up here in the upper Midwest. And so let's work together to figure that out. So I want to talk about lawyers, just period. I want to talk about lawyers. And then I want to talk about what we're trying to do with community bills of rights. And then I want to get into the mechanics of how lawsuits play out within community rights, if there's a lawsuit. That's more or less what I've come up with for this session, and that could easily be enough. But I also want to see what other folks are interested in or what brought you to the room.
Just that, what you just said.
Anything else?
Brian has something.
Yes.
I was wondering if you're going to talk about how to speak and approach elected officials and how to have that dialogue.
I didn't hear that.
How you would speak or approach elected officials to have that dialogue to introduce community rights.
Can I do the other stuff and then
Sure,
get back to that?
yeah,
Because that'll give us more.
You asked what
Yeah.
I was hoping, and that was all I was hoping.
Okay. Anything else?
I guess I'm thinking of how many different ways can these community rights be used within the community. Like thinking outside the box. We already have these sand mines in place, and an outright ban on frac sand mining is going to be a rather steep uphill climb. But how can we use this to make it financially not profitable for them, or to tax them, or to regulate how they do the reclamation, You know, like how many different ways can this actually be used, and is it just an open, is it really outside the box? You know, or are there certain things that can or can't be done with it?
Good question. Okay, I think I'll get that before we get into the mechanics of the Community Bill of Rights stuff. So when I talk about illegitimate legal doctrines and what we're trying to challenge there, I think that sets the frame for what is and what isn't community rights local law. And so that's the time, I think, to engage in that a little more.
I just want to make a announcement that everybody try and speak as loudly and clearly as possible. Not actually for the recording, but for each other. I know that some of us probably don't hear as well as others, so let's keep those people in mind.
Do you have any knowledge of native sovereignty as it relates to community rights? I have quite a few friends that are natives that are fighting frac sand mines. I'm not sure how they would use sovereignty, which is through the U.S. federal government, along with community rights. So.
Yeah, that's an area. There's been some intersection, but it's not really stuck anywhere specifically. However, it's a huge area because we're really wrestling with ideas of sovereignty and legitimacy. In the U.S. legal system, people hold sovereignty as people of the state. We have no sovereignty as the United States. And we don't as local people either. And what we're looking at building when we talk about a right to local community self-government is the idea that people can organize themselves in their own locality to create greater protections for their rights in that space. It is in essence a sovereignty struggle. Now when we talk about native peoples and indigenous peoples in North America, the U.S. Supreme Court has said that Native peoples are sovereign dependent nations. So we have this tug of war between sovereignty and dependency. And that is, I think an area where there's a lot of theoretical intersection, but on the ground, it hasn't really happened yet.
Could it happen?
Yes.
Could they assert their sovereignty to protect their resources?
The same way that people in a county could do that.
So could it be like a double level? They're both a citizen and a member of a native nation, so there could be like two levels to their asserting their sovereignty through the community rights?
To avoid getting too into this,
yeah.
I want to give you a paper by Harvey Walker toward a new theory of home rule that looks at this idea that judges have in the United States and lawyers too, that sovereignty has to exist only in one space. You can only be, a political body at the level of the state.
Okay.
But Harvey Walker, who's a professor, wrote in the 1950s, said, that doesn't make sense with history. That people always exerted their political power. I guess sovereignty is a really strong word. I'll say body politic power or political power at multiple different scales. So people are, New Yorkers are people of the city of New York, and they're also people of the state of New York, right? And they're also people of the United States, and they're also people of North America and people of the world, too. So we should be able to have political power at multiple different scales. It shouldn't have to be a monolithic, you only hold political power at one scale. However, the legal system, basically because of the education of lawyers and judges, holds that, you are only a political actor at one scale. And that, I think, has a lot of challenges with federal Indian law, as it's called, and also with local government law. So it's a very rich theoretical area to explore.
Yeah, it's too bad they can't nest them, one inside the other, inside the other, inside the other, instead of just saying there's only one.
Yeah.
Okay.
So other area?
Yeah. No, same area as you. I'm from northern Minnesota, and Red Lake Band of the Chippewas put up a blockade on Enbridge's pipeline. Back in the 40s, the pipeline came through about, 7 acres, and they never got permission or anything. So the band put up a camp there. Paul went up and visited them. They had a campfire and fence over it, and it was their blockade. They called it the Enbridge blockade. So they were exercising their sovereignty. They even tried to get arrested, and they wouldn't. Enbridge would just wouldn't do anything. The cops were called one time and hauled one gal off, but they took her in their police car and then released her. They didn't want to touch it at all. So if
That's interesting.
yeah, I think it's still maybe going on in some form or another.
There's currently ongoing intersection of indigenous rights, community rights organizing, and climate justice work in Lancaster County, Pennsylvania. I forget what newspaper it's in, but if you look at Lancaster County, Pennsylvania, they've had some civil disobedience, and they're looking at these multiple frames, and it is a non-native and native solidarity movement together. So that's starting to happen in some places, but it hasn't erupted over yet. So I want to start in on experts. And lawyers are seen as experts on the law. And we are supposedly the ones who tell people what's legal and what's not legal, and tell local governments what they should do and shouldn't do. And so I want to just explore kind of where lawyers sit in the big scheme of things. Because a big challenge with this work is that we are challenging illegitimate structures of law. We are challenging the structure that says that ecosystems are property, and instead saying that ecosystems have rights of themselves, that living things have rights, and ecosystems are the living and non-living parts of the natural world. They have rights, right? So we're going against that nature as property doctrine, because when something is defined as property under the law, the property owner has the right to destroy their property. The earth is our property, we have the right to destroy it. It's really that simple when it comes down to rights of nature. There's also doctrines in the law known as Dillon's rule and known as preemption. And what we're saying is that people have a right to local community self-government, which allows people to create greater protections for human rights and environmental rights than provided by state or federal law. So building on this framework, federal law is the minimum rights that we have. State constitutional rights form a third layer or a second layer of rights. And what we're saying is that local law can recognize rights in a way that is more protective than state law. This idea of state law and federal law, the courts already recognize that. It's referred to as the new federalism. Justice Brennan was influential in formulating that idea. That's already recognized, that state constitutions form an independent source of rights that's stronger or more protective than the federal constitutional rights. And we're saying, let's add the third layer, that we can act within our localities to recognize rights, and those rights can be more protective than state rights or state constitutional rights or federal constitutional rights. Just realize state rights means something very different to many people. Third thing then is where corporations fit into all of this. Corporations originally were tools that people used to efficiently manage business and society. They should go back to that role. They shouldn't have independent rights. They should be tools. They should have privileges granted by the people, which the people can revoke. And particularly when the people's rights come into conflict with the corporations, that the corporation needs to be subordinate to the people. So basically, those are the three things that we're pushing for: a new system of law that is in direct conflict to three illegitimate legal doctrines around corporations, around ecosystems, and around communities, and rearranging the power that those three things have within society. So within that, then, we go to the let's say we build a base of support in our community where we say we need to challenge those doctrines, or we get to the point where we've exhausted all the remedies that the law provides for us. And so we're left with no legal options to prevent the harm. At that point, then, we go to our government and say, we want you to challenge these doctrines. I think this work came out of the way this story has been told to me, a phone call between the Community Environmental Legal Defense Fund and a township representative. And the township representative said, look, we've got to stop this huge CAFO. I forget if it was a CAFO, but we'll say it was a CAFO. And we challenge this corporate permit again. And Saldo says, look, we've done that, we've been down that road, and it's not going to work. We'll delay it maybe a year or two, but we're not going to do it. And the reason we can't is because the corporation has rights. And so the township board said, well, can you write us an ordinance that gets rid of the corporation's rights? Sure, but it's going to be challenged in court. And the township said, we don't care. So that's where we have to get. We have to get to the point where we don't care if we challenge those illegitimate systems of law. So we're going to play a little game. We're going to read the Declaration of Independence. Everybody recite what you remember, and we'll see where we cut off. We hold these truths
to be self-evident, that all men are created equal,
that they are endowed by their Creator with certain inalienable rights, that among these are rights to life, liberty, and pursuit of happiness, that to protect these rights, to ensure these rights,
to secure these rights,
governments are instituted among people deriving their just powers from the consent of the governed. And whenever any form of government becomes destructive of these ends, it is the right of the people to alter and or abolish it and to institute new government, laying its principles upon such foundations and organizing its power in such form as to them shall seem most likely to affect their safety and happiness.
So
I just came up with that, actually.
So I'm really impressed because most of us, we remember the beginning, but then we don't get to that second part. And I'll actually read a little bit more, but Forrest has what we call the 4 principles of the Declaration of Independence.
So has anyone ever done that one?
I've never done that before. Oh. But I'll do it.
Well, that's a high standard.
So the first is that people have rights, right? That says life, liberty, and the pursuit of happiness, right? And the second principle is that government is created to protect those rights. Third principle is that government exists based on the consent of the people. And the fourth is that whenever the government fails to do its purpose, which is protect the people's rights, then the people have a right to change their government. And that's the last one. That whenever government fails to do its purpose, people have a right to change their government. And I think Forrest, I might be wrong, but Forrest was the only one who had that part in his active memory.
Isn't it also a duty? Is it just you have a right, or don't you have a duty?
All right. So starting from there where Forrest left off, listen to the rest of that paragraph. And what they do is the authors of the Declaration of Independence say, this is a really serious concern. If you're really going to get to the point of altering or abolishing your government, it's got to be some pretty serious grievances. You've got to talk about some serious wrongs here if you're going to go to that crazy length to do that, even though they say we're about to do it, right? There's all sorts of political reasons. They wanted to get France's support against the King of England, stuff like that. But so there's those 4 principles, and the fourth one being that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. So the right to change your government when it fails to support your rights. So as you listen to them build up to what it should really take, this is a serious act, I'm going to then read the first 3 accusations against the king. And those accusations, we'll talk about those because I think they're very telling for the situation we have now and for the unjust legal systems that we're trying to change through community rights lawmaking. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes. And accordingly, all experience hath shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, and evinces a design to reduce them under absolute despotism, it is their right, it is their duty, to throw off such government and to provide new guards for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. All right, what is this awful, heinous, despotistic, usurpicious king done to these people of these colonies? 1, he has refused his assent to laws, the most wholesome and necessary for the public good. Right? So the people have tried to pass laws to protect themselves, and the king has refused to let them do it.
Sounds familiar?
Yeah.
2, he has forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained. And when so suspended, he has utterly neglected to attend to them.
Sounds familiar?
So, when King Walker says, hey, the people of Wisconsin and the local governments can't regulate frac sand mining, what does that look like? And then number 3 is he has refused to pass other laws for the accommodation of large districts of people unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only. Right? In other words, if you want to make laws, you have to give up your self-government power, and then he'll consider making laws.
Is that new areas only?
He has refused to pass other laws. There's a book on I forget. If you look up Declaration of Independence and books on the Declaration of Independence, there was one from the early 20th century, I'm forgetting the name now, that actually looks at the merits of these various claims. And when you get down to the weeds on some of these claims of the Declaration of Independence, he has caused people to be kidnapped and forced into working for the British military. That might have happened, but it might not have happened. They might have made up some of these claims in the Declaration of Independence. But these 3 ones at the top, they're at the top of the list for a reason. Because the people of the American colonies were trying to create laws and were unable to do so because of control from the king and from Parliament. Right? So here we're talking about, this is a pretty serious document. I mean, the right to alter or abolish your government when it fails to protect your rights is a pretty serious thing. And, they didn't take it that, lightly. I mean, the people who signed their names to this would have been hung if they were caught, right? So it's a pretty serious affair. But what they're talking about is the right to create your own laws. And that's what we're talking about too, is the right to create a new system of law that rebalances the relationships of power between communities, between ecosystems, and between corporations.
Didn't also part of that have to do with the king was replacing the judges, the American judges, with loyalist judges?
Mm-hmm.
And there was a revolution before the real revolution. They never fired a shot in Massachusetts, and that was part of it too.
Yeah, and the people between 1773, when 90 different local governments passed their own declarations of independence, and then 1776, when things started to erupt and it became a violent conflict, there was a whole nonviolence movement against British rule, which included going to the courts that had been set up by Britain and saying, "Judge, thank you for your service, but it's time for you to go." So it was a nonviolence movement. I would emphasize that we've learned a lot about nonviolent strategy in the last 250 years or so. So I think we don't have to say, well, if you're looking at an American Revolution, you're looking at a lot of violence. I think we're in a different place now in the world. So that's just an aside. So thanks for playing that game. So here, yeah.
Well then, so couldn't, say, a group of Wisconsin citizens get together and sue Walker for going against the Declaration of Independence?
You could.
Get rid of him?
You could sue Walker for doing that.
Yeah.
The problem
Well,
is
hold on.
the courts generally say that United States law begins with either the state constitution, which in certain states, like the original colonies, their state constitutions predate the United States Constitution. But otherwise, U.S. law starts with the U.S. Constitution. So in law school, as a lawyer, we spend half a period on the Articles of Confederation, which was the first United States Constitution, which basically says they didn't work, and this is why. There wasn't a strong enough centralized government. So that's why we created the United States Constitution.
Yeah.
And then law begins. So that's the beginning of constitutional law, is with the U.S. Constitution. The Declaration of Independence, you learn in law school, if you're making a legal argument based on the Declaration of Independence, it's a good sign that you have a losing legal argument. On the other hand, we're losing against these illegitimate systems of law, and we don't have remedies within the system. So we have to go outside the system. Just like Susan B. Anthony went to vote in the 1870s. Was it legal for her to do so? Was it right for her to do so? Right? There we go. So lawyers are trained in the law, which means U.S. Constitution forward, not these ideas that you have the right to alter your government when it fails to support your rights. And lawyers work for our governments, right? So there's the local government, which is, the people elect a board or supervisors or commissioners or any other terms for it?
City councilors.
The city councilors, right? So that's the board of, basically the board of directors, just like a corporation. So the board of directors then tells the managers what to do, right? And basically tells the city staff what to do or the county staff what to do. And the board of directors tells, basically hires the lawyer and tells the lawyer what to do. That is the relationship, is that the directors or city councilors or supervisors, whatever term you want to use, are the principal, the ones who are in charge, and the lawyer is the agent, right? The lawyer works for the client, not the other way around. I think there's a challenge in local government organization in that board of directors comes and goes, and the city, the local government staff know it. So if you've got a elected official who's kind of a thorn in the side, you just have to wait 4 years, and then they'll be gone. Meanwhile, you're a career employee of the local government, so you know what's really going on. So in a way, like the employees have become the managers, and I think that's particularly dangerous when it comes to the relationship between the board and the attorney. So that's something I want to emphasize, because I've heard that there's often, the board will defer to the attorney. It's like, okay, the board says, yeah, we want to pass this, we want to pass this, we want to pass this. What does the attorney say? As if the attorney is on the board,
Yes.
right?
Yes.
And the attorney says, no, this could be unconstitutional, we could be sued. And then the board says, well, then we will listen to our agent, right? So part of this, and why I critiqued experts earlier, is that we need to say, lawyer, we respect your opinion and we value it. It's important for us to know that. But we're in charge of what we pass, and we want you to defend it, and we're going to pass it even if you say that it's probably unconstitutional, or it is dead certain unconstitutional, or whatever the lawyer wants to say. So we need to reassert that control, because the lawyers are generally going to stay in the box of allowable remedies, and they're going to say, you can't do that because, okay, what do we do to protect ourselves from the frac sand harm? And they say, go to Governor Walker and ask him to pass, ask the state legislature to pass a law to protect us. And it's like, okay, great, but what if you recognize that the state legislature is run by the companies that we're trying to oppose, where do we actually have a way to get around it? In law school, I see your question, sorry, I'm on a roll. In law school, we see, we don't get into critical theory or critical analysis of how power works. There are some law school professors who do that kind of stuff, critical theory, or really looking at, why would you go to the state legislature when that's where the power is even more concentrated and corporations have even more power there. So that kind of perspective that the system is fixed and it's fixed against the people protecting themselves is not a perspective that's easy for a lawyer to get. And so I'm making a lot of generalities here, but it's based on my own experience. It's based on my readings of the psychology of lawyers and the psychology of law students, and who then become lawyers and judges. There's a great Harvard Law School paper called Making Docile Lawyers, an essay on the pacification of law students. And so, these are often folks who go into a career trying to do good, trying to create social justice. I mean, a lot of people interested in engaging in civics, and they go through a process of becoming, someone who is subordinate to a certain way of thinking and a certain framework. All you have is a hammer, every problem is a nail, and that's kind of it. So we run up against those experts in the community rights framework, which is why I wanted to do that Declaration of Independence exercise, because we need to become the experts of what we need to protect our health, safety, welfare, and happiness. And if we're not those experts, then I think we've lost from the very beginning.
My question is about the accountability piece. Every board has a mission and a code of ethics that they're supposed to follow. If they're falling way outside of that, why can't the community just say, you're not doing your job, get them out, without waiting for the election cycle? If they're not doing their job, where does that accountability piece come in?
You can impeach county board members who did that here in Trumbull County.
You impeached them?
Yep, we got some kicked out right in the middle of a term because he was the head of the jail study committee in Trumbull County, and they were trying to build a $20 million jail based off of fictitious studies that we found the errors in the study, that they basically copied a study from another state and put the word Trumbull County in there and made it look right, and we caught him dead bang, and we got the guy kicked out of office and replaced midterm.
So then what's the burden of evidence for something like
recall
that?
Election got and won hands down by a landslide. That was just, it was amazing.
Sounds like you have recall elections in Trumbull County.
We have the ability to do it and we've done it.
Yeah, so if you've got the ability to do it, you can do it. In terms of the board breaching their duties, in most, we don't want elected officials to be responsible for every consequence of every decision that they make. Imagine if you were deciding whether to change the speed limit on a road and you raise the speed limit 10 miles per hour and then somebody dies in a wreck. Who are you going to sue? The decision makers who just raised the speed limit, right? So we don't want that system. We want the representatives to be able to make decisions without fear of personal liability. So we grant tremendous amount of immunity to lawmakers when they're doing their lawmaking thing. That means that lawmakers are usually not able to be sued in their personal capacity for doing things, even doing things that are perceived to be illegal. Did Obama know that the Patient Protection Affordable Care Act, Obamacare, would be legal before he signed it? No, and in fact, part of it was unconstitutional according to the U.S. Supreme Court. Lawmakers pass things all the time without knowing what the result is going to be, right? And there is enough wiggle room in this. There is enough wiggle room in this in that we are pushing new areas of law, and we have, I think, a pretty strong foundation for arguing what we're arguing, even though the courts have not accepted, that we have not gotten the backlash of being found to be frivolous. So this is frivolous. your lawsuit is frivolous is basically if somebody sues you for no good reason whatsoever, just to harass you, then you shoot back and say that they filed a frivolous lawsuit, and that's where the judge says, yeah, that lawsuit was frivolous, and therefore I'm going to award a bunch of attorney fees against the party that was sued and maybe sanctions and really punish the people who were frivolous. We're in court arguing the right to local community self-government. I signed the papers for trying to get an ecosystem into court. And the other side screams bloody murder, but they're not filing bar complaints against me, and they're not asking the judge to find that my action was frivolous, which means that they're not choosing to exercise some of the remedies that the procedural rules do allow within court, which I think is a sign that we actually have an argument in what we're doing. So I can't speak to the specifics for representatives who are actually saying, I'm on the board and I'm going to sign my name to pass a community bill of rights. I think it is a very brave thing to do, and I think you should be commended for doing it. And generally speaking, you will have immunity for what you sign your name to when you pass legislation. However, the specifics of it, you need to talk to the county attorney and figure out, what is the immunity situation there. Go ahead.
Well, a comment about the county attorney. I'm on the county board, and for those of you that don't know, in Wisconsin, counties have a position called corporate counsel. That's the attorney the county hires to take care of its civil matters. The district attorney takes care of criminal issues. But the wording in the law on the duties and who the corporation counsel serves is very vague. And so you find corporation counsels picking and choosing who they decide they're serving depending on the case. In other words, in our case, he likes to serve the county board chair, who I call the Scott Walker of Sauk County. So that's a problem that you have to be prepared to deal with when you're dealing with county boards and county board decision making, etc., because it's really hard to pin down exactly what the law says about who that corporation counsel's client really is. Ours has claimed attorney-client privilege regarding some communication he's had with the county board chair about county board business, when a county board member like me wants to know what that's about, because they're talking about county business. I think the public has a right to know what that communication's been about. When I have asked the corporation counsel for a comment or a legal opinion, I've always made it very clear that I expect that whatever he reports will be made available to the entire county board and to the public. And one time he refused because he said he was not my personal attorney. And if I was feeling particularly nasty that day, I would have responded and said, look, if I want to hire a personal attorney, I will hire somebody competent.
That was right.
And that same person, the county board, decided to increase the photocopy fees for open records like the $2 a page, which is illegal. It's a get out. And our corporation counsel said that was legal. Fortunately, the Wisconsin Attorney General's office disagreed with them. But anyways, so there can be real issues dealing with corporation counsels at county.
Yeah, it's a challenging issue for an attorney. I mean, just to give him some creds, it's a challenging issue for an attorney when you're representing an entity that does not actually exist, but has a bunch of different spokespeople. Who's your client? It's a problem for corporate attorneys who represent a business, and it's a problem for government attorneys who represent the government. So here's the county, right? I'll just use county, but this general framework should work for any local government. And I don't know about the specific law that you referred to about who the county attorney works for. But the general rule is that here's the residents of the place, right, the people, and they elect the board, and then the board appoints the staff and the staff includes an attorney or multiple attorneys, right? Or in the case of the district attorney, sometimes that person's elected as well. That's the same basic structure as a corporation, right? Where you have the shareholders elect a board of directors who appoint the managers, which is sometimes why local government law is called municipal corporations. So the county then passes a community bill of rights. So the county creates a community bill of rights. Basically, the board of directors or the decision makers, they use the county to create a community bill of rights. So when the board acts as an official entity, that's when it is acting as the decision maker for the county. So it'd be interesting to tease apart the situation with your county attorney, but because when you're speaking to him as an individual board member, you're just an individual. It's when the board acts as a board, when the board of directors or the supervisors act as a board, that they are actually the decision makers for the entity that's involved. So the entity creates a community bill of rights, and in many cases this is where it ends. While the community bill of rights framework has evolved over the last 15 years or so, we've had, it's changed dramatically, and we've had about 8 substantive challenges to the about 200 community bills of rights that have passed. So in most cases, a corporation looks at the community and says, well, they passed this law that we think is blatantly illegal and goes against these well-settled legal doctrines about how we as a corporation have rights, but they don't challenge it. Instead, they move somewhere else, and they go to someone else's backyard, and we're sorry for those other people, and we'll be happy to work with them, but the corporation has left that locality.
Have all 8 of those challenges been successful?
They're increasing, and we expect them to increase as we're getting more and more pushback. We don't expect to win the lawsuits, which I think is a really important thing to say. Right? That we know that we're challenging these deeply rooted structures of law under authority, the right to local community self-government, and the rights of nature. That does not exist. And so we know going into this that we're challenging systems of law that are very firmly embedded in a conservative court climate. I mean, it's not the 1960s when every U.S. Supreme Court justice was, appointed by FDR and Truman, and it was this almost radical court. It's a very conservative court climate. So I think that's important to say. So, and then most of them are a process. They take multiple years to litigate. So then a corporation comes in. I'll call it the corporate perpetrator. The corporate perp wants to get rid of the CBR, the Community Bill of Rights. Sorry about the acronym. And so to do that, it's going to sue the county. Right? If the corporate perp has hired bully attorneys, they'll sue the board of directors as well. Like, we'll name them individually, which is just BS, and they should get sanctions for doing that because that's blatant crap. They're not going to sue the residents of the local government. Probably not going to sue the staff. They're going to sue the legal entity, the county, which is the proper party to sue. And they're going to say that this community, and their goal is to get this Community Bill of Rights to be struck down, so to knock that out, and say that that's an invalid law. And their arguments will be that they, as a corporation, have constitutional rights, that the local government had no power to pass this law, which is a variation of Dillon's rule, that this law is preempted by state law or federal law, and that's usually about it in terms of what their challenges are. But that's a whole laundry list, because the constitutional rights are a lot of different things. At that point, the county attorney is the one who is responsible for responding to this lawsuit. And the county attorney pulls out that Community Bill of Rights and says, "Board, what were you thinking? I told you not to pass this in the first place. Told you so." Right? told you so. Like, you don't follow my advice, and don't follow the experts, and this is what happens. So the county attorney most often is not interested in defending the Community Bill of Rights and is going to try to say, we need to settle with the corporate perp. And we need to agree, okay, corporate perpetrator, we'll take the Community Bill of Rights off the books, withdraw that, and in exchange, you'll drop your lawsuit, and we'll just go home as if nothing happened. In that case, you basically bought yourself some time. I mean, if the local attorney settles. The local attorney doesn't have the authority to settle for the county. The people who have the authority to decide to settle are the county board. However, there's another player in here. Anyone want to guess who the other player is? Not the judge. Not the people.
Insurance company.
Insurance. They have their own attorney that comes in and backs us up or kicks us out.
Yeah, the insurance company. The system is rigged. And it is rigged. So the county has an insurance policy. The insurance policy is different based on the whoever the insurer is. The insurance policy probably says that the county needs to notify the insurer when the county has been sued. So one of the first things that the county attorney or somebody else on staff of the county has done is notify the insurance company about the lawsuit. The insurance company, just like the county attorney, has a bunch of lawyers in it, and they say, what were you thinking? You can't go against corporate constitutional rights and this other stuff. So the insurance company agreement between the insurance company and the county might say something like the insurance company gets to direct the litigation, or that the insurance company does not have to defend certain acts of the county, such as those acts that are blatantly unconstitutional or something like that, right? There's an issue here depending on the particular language of the insurance policy, but it should be expected that this is going to be an issue where the insurance company gets to team up with the county attorney, and both of them say, county board, you need to settle this ASAP and get out of this lawsuit, right? The insurance company then, if the county board says no, will make another lawsuit. So insurance versus county, to try to get the court to declare that the insurance company's policy does not cover the county's defense of its Community Bill of Rights against the corporate perpetrator. Right? So the insurance company is trying to basically sever this tie right here so that the insurance company doesn't have to pay the corporate perpetrator for the corporate perpetrator's expenses of bringing this lawsuit against the county if those expenses were incurred against the county.
Lindsay, just wanted to let people know it's 8 minutes until done.
Thanks.
So they actually sue the municipality?
It's referred to as a declaratory judgment action in most states. And it basically is asking the court to declare whether a particular contract means a certain thing. In this case, the insurance company is most likely asking the court to declare that its contract with the county does not require it to defend the Community Bill of Rights. That is outside of the insurance policy.
Has this happened?
Yes.
Where?
I can't tell you.
Can you preemptively make sure your insurance is going to cover it before you pass the Community Bill of Rights?
It's worth doing. Yeah.
Okay.
Yeah.
So what's the outcome? What happened?
Well, we haven't found out yet.
That's why you can't tell.
The judge has said. The judge has said, you can't bleed a stone. And so the corporate perp. I don't know. it means that the judge. But here's the thing. In that case, and I'm sorry for not being able to tell you which case it is. In that case, it's been fully briefed. We've laid out the argument of the right to local community self-government. The corporate
fully briefed means what?
Fully briefed means all the documents are in, right? For reciprocal motions for judgments on the pleadings, which just means here's all the documents. The judge has all the arguments in front of her, and she can say who wins and who loses. So she has all the information she needs right now to say that the Community Bill of Rights is invalid and needs to be struck. But instead, she says you can't bleed a stone, and I'm going to appoint a special investigator to look into the details of what's going on in this place and figure out if there's some kind of intermediate thing that can be done.
Compromise.
She's trying to compromise, and it's a Community Bill of Rights. I mean, it's like blatantly challenging the legitimacy of the system. So it's an interesting development.
So what about jury? Can we get in front of a jury with this case?
So let's see. Yes, let me do that. Let me do the jury and then intervention. So one question about can you get in front of a jury? Jury decides questions of fact. The judge decides questions of law. The difference is that questions of fact are like, I say that Layla hit me first, and Layla says that she hit that I hit her first, and who's lying, right? That's a question of fact. So that goes to a jury. A question of law is something like, does the State Oil and Gas Act preempt the local law, right? That's a question of law. We don't turn that over to a jury to decide what laws preempt and what laws don't preempt. The judge is considered in the courtroom to be the expert on the law. So that's why questions of law go to the judge. So these typically don't go to a jury, even though we would demand a jury on any issues that we can. We typically don't. One other question, then I'll get to yours. There's a question of intervention. So notice that the residents are not part of the lawsuit, right? The residents get to speak by electing their board. That's it. And then go home and enjoy the next 4 years and come back and participate later. So we have often in this situation decided that the residents are going to get in the middle of this and intervene in this lawsuit. So the residents try to join the county as defendants, right? And that way we can bring a Community Bill of Rights defense to the Community Bill of Rights when the attorney is not doing that, right? The problem is the court will sometimes say, no, you can't do that because the county represents your interests as residents, and therefore you're already represented in the lawsuit. We don't need you involved. Thank you for your consideration. Please go home and stop being these mere interlopers in the affairs of the corporation and your county government. So that's one strategy that we've tried, and sometimes we're able to intervene. It's more effective in the federal courts. It's been less effective in state courts. And so what we've tried a few times at that point is then have the residents basically sue the corporate perp, the county, and the state for violation of the right to local community self-government by having a state law that preempts the local law in the first place. So we have that going on in 2 counties as well. So that's an interesting tactic that's developed in the last couple of years. So there are, I guess, to try and close in the 1 minute that I have, there are tactical things that we can do here within this lawsuit, but it's a big mess. It's a very tight system, right? And it's something that I think people get to when they have no other options within the existing system. On the other hand, we know that the legal system changes. If we look at history and we look at who had power and who was considered property 200 years ago, we know that the system changes. We're not getting attacked in certain ways, like this is a frivolous lawsuit, or challenging our bar licenses for doing some of the things we're doing. Local elected officials are protected by immunity for the most part, but please do check with your county attorneys on that matter. So we're not getting the worst pushback that we could be getting, which suggests that it's moving in the right direction, even though we're still losing. If that's fair to say, we're like Susan B. Anthony in the 1870s, right? We're still losing, and we're going to be losing for a long time. But the arc of history tends toward justice, as they say.
But you need more young people then, because I'm going to be dead in my grave before this evolves.
Me too.
No.
No, not that long.
So that's where what we've been talking about is that the Community Bill of Rights says that this corporate perp doesn't even have the right to bring this lawsuit in the first place, right? Because we're saying that when the corporation challenges the community's rights, the community's rights trump the corporation's rights, and in fact, the corporation loses its rights to the extent necessary to protect the Community Bill of Rights. That's in the Community Bill of Rights. It's part of the law that we think should exist. I'm really sorry I haven't got to your question yet. So one thing we've been talking about is, while this whole machine is grinding over here, what do the people do? You know, the people can try to intervene, but that's not necessarily going to be successful, right? The people are locked out of this system, with the exception of being able to vote for your board. So there's another leverage point, which is who decides this lawsuit, corporate perp versus county, is decided by the judge. And so what if the residents go to the judge in various ways and tell the judge, look, judge, these are our rights. This is what government is for. And we're not going to tolerate this corporation stepping into our courtroom. Because that corporation doesn't have the right to do that. In fact, it doesn't have standing to do that. You as a judge can decide standing on your own without waiting for the county attorney to raise the issue. So we would like you to raise the issue standing and kick the corporation out of court, because the Community Bill of Rights says that the corporation doesn't have the right to be there to challenge our law in the first place. So I just want to throw that out as an idea that let's recognize when this game is working, let's recognize when it's not working, and let's recognize that what we're doing needs to challenge illegitimate structures of law creatively, and might require not just using the legal system, but also going to other avenues of connection and channels. Judges care about the world that we're in. Lawyers do too. And so let's appeal to that humanity, and let's appeal to their sense of community within our community, and go directly to them and say, Judge, you have the power to just dismiss this thing for lack of standing, and do it now. And that's what we want you to do.
And the more of these we have, the harder it is for the corporations to fight us. That's right. Then they got to fight everywhere.
Yeah.
Lindsay Rock.
All right, so I apologize for going over, and I'm going to answer your question first thing, but let's break. And thank you so much for letting me go through this crazy rigmarole. I'm happy to take questions during the break or after the next session.